You are not driving. You did not do anything. The car is not yours. And now the officer is leaning past the driver's window, looking directly at you and asking for your ID. And every instinct you have, every social reflex, every authority compliance mechanism, every piece of experience that tells you when a police officer asks you something you answer it, is pushing you toward reaching into your pocket. Stop. Because what you hand over in the next 5 seconds starts a database query on your name, your record, your warrant status, your prior contacts, and every flag attached to your identity in every system that officer can access. You did not start this stop. You are not responsible for this stop. And in most states, in most situations, you are not legally required to hand over a single piece of identification. Knowing that before your hand moves is the difference between a traffic stop that was never about you and an arrest that was never supposed to happen. Subscribe to this channel, like this video, and drop a comment below telling us what state you are in. Because passenger ID law is one of the most jurisdiction-specific areas in traffic stop rights, and your comment tells us exactly where to build next. Before the exact words, you need to understand why the passenger's legal position is different from the driver's. Because most people assume that whatever the driver is required to do, everyone in the vehicle is required to do also. That assumption is wrong, and the legal reasons it is wrong are the foundation of every right you have as a passenger in a stopped vehicle. The driver of a vehicle operates under a licensing framework. A driver's license is a state-issued privilege granted on the condition that the license holder comply with certain requirements, one of which is producing the license upon lawful stop. That obligation flows from the driver's relationship to the vehicle and to the state's licensing authority. It does not flow from the passenger's presence in the vehicle. The passenger has no licensing relationship with the state that created the production obligation. The passenger is not operating the vehicle. The passenger is not the registered owner. The passenger's presence in a stopped vehicle does not, by itself, create any identification obligation under the traffic stop framework that governs the driver. The traffic stop's constitutional predicate, the reasonable articulable suspicion of a traffic violation that justified pulling the vehicle over, applies to the vehicle and the driver. It does not automatically extend as an identification requirement to every person inside. For the driver's ID obligation to extend to passengers, something additional must happen. The officer must develop independent, reasonable, articulable suspicion that the passenger specifically has committed, is committing, or is about to commit a criminal act. Absent that independent basis, directed specifically at the passenger, the identification request is a request, not a legal requirement, in most jurisdictions. Here is the Supreme Court decision that is most commonly cited to justify passenger ID requests, and understanding what it actually says, as opposed to how it is used, is what gives passengers the legal ground they need to stand on. In Arizona versus Johnson, decided in 2009, the Supreme Court addressed whether an officer conducting a lawful traffic stop could detain a passenger for the duration of the stop and question the passenger. The case arose from a Tucson gang interdiction stop in which a passenger, Lemon Johnson, was asked to get out of the vehicle and was subsequently questioned and patted down. The court held that the authority to detain a passenger for the duration of a lawful traffic stop does not require independent suspicion directed at the passenger, the rationale being that the stop has already seized everyone in the vehicle for Fourth Amendment purposes, and requiring the passenger to remain for the stop's duration is a reasonable extension of the stop's intrusion. Here is what Johnson did not hold. It did not hold that passengers are required to provide identification. It did not hold that officers may conduct a pat-down of a passenger without independent, reasonable, articulable suspicion that the passenger is armed and dangerous. The court explicitly noted that the pat-down required its own Terry justification. It did not hold that passengers must answer investigative questions. What Johnson established is that a passenger may be detained for the duration of a lawful traffic stop. What the passenger must do during that detention, beyond remaining present, is a question Johnson left to the existing constitutional framework. And that framework provides significant protection that most passengers in a stopped vehicle have never been told they have. Here is where the passenger's legal position plays out in practice. Because the ID request arrives in 5 distinct forms, each with a slightly different legal analysis and a slightly different correct response. The first scenario is the blanket request, The officer asks everyone in the vehicle for identification simultaneously, treating the passenger request as an obvious extension of the driver request. This is the most common form and the one that produces the most unreflective compliance. The second scenario is the targeted request. The officer has had some interaction with the vehicle's occupants and then specifically asks the passenger for identification, sometimes after the driver's documents have already been processed. This form often carries an implication of independent suspicion that may or may not actually exist. The third scenario is the exit and ID request. The officer asks the passenger to step out and then asks for identification once the passenger is standing on the road. This combines the Mims-Wilson authority to order passengers out with an identification request that is presented as part of the exit compliance. The fourth scenario is the officer's safety framing. The officer says something like, "I just need to know who I am dealing with," or it is standard procedure to get everyone's information, framing the request as a safety or administrative matter rather than an investigative one. The fifth scenario is the criminal investigation transition. The stop has escalated from a traffic matter to a suspected criminal investigation, and the identification request is part of the escalated investigation. Each of these scenarios has a different legal analysis, and deploying the same response to all five without understanding the differences produces the wrong outcome in at least two of them. Here is the legal landscape across jurisdictions, and this is the section that most passengers will find most surprising, because the protection is broader than almost anyone has been told. In states without a stop and identify statute covering passengers in traffic stops, which includes a significant number of states, a passenger who has not been independently suspected of criminal activity is not required to produce identification during a traffic stop. The officer's authority to detain the passenger for the stop's duration, established by Johnson, does not transform into authority to require identification absent independent suspicion or a specific statutory basis. In California, which lacks a broad stop and identify statute, a passenger generally cannot be compelled to identify themselves absent independent reasonable suspicion directed at them. In states with stop and identify statutes, the analysis depends on whether the statute explicitly covers passengers in traffic stops or whether it is limited to persons detained on reasonable suspicion of criminal activity, which returns to the question of whether the traffic stop itself provides that basis for each individual in the vehicle. Texas, which has one of the broadest stop and identify frameworks, has case law examining the degree to which the traffic stops basis extends as a detention basis to passengers. Nevada, which produced the Hybel case, has addressed the stop and identify question in the traffic context. The variation across these jurisdictions is significant. What is consistent across virtually every jurisdiction is this: a passenger who is not independently suspected of criminal activity has more protection than they are typically told at a traffic stop window, and the officer's request for identification does not carry the same legal force as the driver's statutory obligation to produce a license. Here is what most passengers do when the officer's attention shifts from the driver to them, and both responses leave them worse off than the situation required. The first passenger reaches for their ID immediately. They see the driver handing over a license, and they assume the same obligation applies to them. They hand over identification that was not legally required, triggering a database query on their name and everything attached to it. If they have an outstanding warrant for a missed court date, a parking fine that escalated, anything they may not even be aware of, the query surfaces it. The identification that was never required just produced an arrest that was never supposed to happen from a stop that was never about them. The second passenger refuses loudly and with hostility. They tell the officer they do not have to show their ID, and they are not going to. The body cam captures the tone. The officer's report documents a passenger who was uncooperative and agitated. The agitation itself becomes behavioral data. And depending on the jurisdiction and the specific circumstances, a hostile refusal to identify in a context where some identification obligation may exist produces worse legal exposure than a calm, legally precise invocation would have. There is a third path, the one that is calm, specific, legally grounded, and puts the right question on the record before anything changes hands. And it begins with understanding that the passenger's first obligation is not to answer the ID request. It is to find out whether the ID request carries a legal obligation in the first place. So here are the exact words, structured around the passenger's specific situation because the passenger's response sequence is different from the driver's. When the officer directs any attention toward you as a passenger, any request for identification, any question about your identity, any instruction to produce documents, before anything leaves your hands or your mouth, you say this calmly and clearly. Officer, am I being independently detained, or am I free to go? This question does two things simultaneously. It establishes whether the officer has developed independent, reasonable, articulable suspicion directed specifically at you. Not at the vehicle, not at the driver, not at the stop's original basis, but at you specifically. And it puts the answer on camera before any identification changes hands. If the officer says you are free to go, you can leave. The stop was not about you. The ID was not required. Thank you, officer. And you exercise the answer the law just gave you. If the officer says you are being detained, now you ask the follow-up. Officer, on what specific basis am I being independently detained as a passenger? This question requires the officer to articulate the independent, reasonable, articulable suspicion directed at you specifically. Not the traffic violation, not the smell of something, not a general suspicion about the vehicle. The specific, articulable basis for detaining you as an individual. If he articulates one, evaluate your jurisdiction's stop and identify law for whether it requires you to produce identification during a lawful detention. If he cannot articulate one, officer, I do not believe I have been lawfully detained, and I am invoking my right to remain silent. I will not answer questions without my attorney present. If the stop is in a state with a clear stop and identify statute covering passengers, and the officer has stated a lawful detentional basis, provide your name if required. Nothing more. Then, I am invoking my right to remain silent on any further questions. Here is the specific escalation that follows a passenger ID request most often and that most passengers are least prepared for, because the pat-down and the ID request are almost always connected, and knowing about one without knowing about the other leaves you half protected in an encounter where half is not enough. When an officer requests identification from a passenger and then orders the passenger to exit the vehicle, the exit order combined with the officer's stated or unstated claim to be concerned about weapons can transition very quickly into a pat-down request. Under Terry v. Ohio, a pat-down of a passenger requires independent, reasonable, articulable suspicion that the passenger is armed and dangerous. Not armed. Armed and dangerous. The Johnson decision confirmed that the authority to detain a passenger for the stop's duration does not automatically confer authority to pat the passenger down. The pat-down requires its own Terry justification. The officer who asks you to step out, who asks for your identification, and who then says he is going to check you for weapons has moved through three distinct legal questions: the exit authority, the identification authority, and the pat-down authority, each of which requires its own independent justification. Most passengers, having already complied with the exit order and the ID request, comply with the pat-down also because the sequence has established a compliance register that makes each additional request feel like a natural continuation of what came before. It is not a continuation. It is a separate legal request with its own constitutional standard. When the pat-down request arrives, officer, I do not consent to any pat-down or search of my person. Do you have independent, reasonable, articulable suspicion that I am armed and dangerous? Say it. Do not physically resist. Get it on camera. The non-consent and the demand for the legal standard are the foundation of a suppression motion if the pat-down proceeds anyway. The officer will push back, and at a passenger ID stop, the pushback almost always takes one of three forms: authority assertion, safety framing, or consistency pressure. Know all three before they arrive. If the officer says everyone in the vehicle needs to show ID, this is an authority assertion that implies a universal obligation that does not exist in most jurisdictions for passengers. Officer, am I being independently detained? On what specific basis? If the officer says it is standard procedure to get everyone's information, standard procedure is not a constitutional standard. Your response does not change. If the officer says, I need to know who I am dealing with for safety, officer safety is a recognized interest, but it does not override the constitutional requirement that a detention or a search of a person require independent justification directed at that person. Your response does not change. Officer, I am invoking my right to remain silent, and I do not consent to any searches or pat-downs. If the officer says the driver showed their ID, you need to show yours too. The driver's statutory obligation to produce a license is not transferable to passengers. Your response does not change. If the officer transitions from ID request to pat-down request, Officer, I do not consent to any pat-down or search of my person. Do you have independent, reasonable, articulable suspicion that I am armed and dangerous? If the officer orders you out of the vehicle, comply with the exit. Wilson established that authority. As you exit, Officer, I am complying with the exit order. I am invoking my right to remain silent, and I do not consent to any searches or pat-downs. The exit and the compliance do not extend to the identification or the pat-down. Each is a separate legal question. If handcuffs come out, I want an attorney. For words, everything stops. Here is the section that requires the most honesty, and it is the one that determines whether the information in this video protects you or complicates your situation. If you have an outstanding warrant, a missed court date, an unpaid fine that has been converted to a warrant, anything that is in the system under your name, the database query that follows an identification production will surface it. An officer who runs your name and surfaces an active warrant is not conducting an unlawful arrest. The warrant exists. The arrest is its lawful consequence. No amount of legal precision about passenger identification rights changes the legal validity of a warrant arrest. What the passenger ID rights information in this video does in the warrant context is create a window. The window between when the officer requests identification and when it is produced, in which you have the opportunity to understand the situation before the identification query starts. If you know you have an outstanding warrant, you know what identification production will produce. The decision you make in that window is yours. This channel provides the legal framework. The application of that framework to your specific circumstances requires honest self-knowledge about what that query is going to return when your name goes into the system. Know what is in your record. Know what is outstanding. Know what the query is going to find before the query runs. That knowledge, combined with the legal framework this video provides, is what allows you to make an informed decision rather than a reflexive one. The body cam captures the passenger ID exchange from the moment the officer's attention shifts from the driver to the passenger. And for cases where a passenger's identification led to an arrest, the body cam footage of that exchange is the primary evidence in any suppression motion that follows. The suppression motion will argue that the identification was not legally compelled, that no independent, reasonable, articulable suspicion directed at the passenger existed, that the database query and its results were the fruit of an unlawful identification compelled without constitutional authority. That argument requires the body cam to show a passenger who asked the right questions before handing anything over, who asked whether they were independently detained, who asked for the basis of the detention, who invoked the right to remain silent before any question was answered, and who stated non-consent to any search before any search was attempted. A body cam recording that shows a passenger reaching for their wallet the moment the officer looked at them, with no question asked, no basis requested, no right invoked, is a recording that shows voluntary identification. Voluntary identification is not suppressible. Compelled identification without constitutional authority is. The question before the wallet opens is the distinction between those two recordings. Ask it. Get the answer on camera. Let the answer determine what happens next. Memorize these before you close this video. When the officer requests your identification as a passenger, before anything changes hands, Officer, am I being independently detained, or am I free to go? If free to go, exercise the answer. Leave or stay, but know it is your choice. If detained, Officer, on what specific basis am I being independently detained as a passenger? If the basis is articulable and your state's stop and identify law covers this situation, provide your name if required. Nothing more. Then, I am invoking my right to remain silent on any further questions. If no independent basis is articulated, Officer, I do not believe I have been lawfully detained, and I am invoking my right to remain silent. I will not answer questions without my attorney present. If an exit is ordered, comply. As you exit, I am complying. I am invoking my right to remain silent, and I do not consent to any searches or pat-downs. If a pat-down is attempted, officer, I do not consent to any pat-down or search of my person. Do you have independent, reasonable, articulable suspicion that I am armed and dangerous? If handcuffs come out, I want an attorney. One question asked first. Every scenario addressed by its answer. This is educational content only and does not constitute legal advice. Always consult a licensed attorney in your jurisdiction for guidance specific to your circumstances. If this video gave you the passenger rights framework before you ever needed to use it from a back seat, it did exactly what it was built to do. Subscribe to this channel and like this video right now, because passenger ID rights are one of the least covered and most needed areas of traffic stop law, and most passengers have been handing over identification for years without ever knowing they had the right to ask a question first. Every like puts this video in front of a passenger who is going to be in a stopped vehicle this week and who is going to reach for their wallet the moment an officer looks at them, because nobody told them they had another option. Drop a comment below with your state and whether you have ever been asked for ID as a passenger, because your comment tells this channel exactly where passenger rights education is most needed and shapes the jurisdiction-specific content we build next. One scenario, one question, asked before anything leaves your hands. Everything else follows from the answer. Stay calm, stay protected, stay free.